There's a political term that gets tossed about all the time these days. I hear it all the time, and sometimes I cringe a little bit. Not that it's misused, but I think that the vast majority of people who use this term only understand one aspect of it, and the other aspect, which arguably is the more important aspect, is lost or forgotten. That term is rule of law. And invariably, when people use it, they're talking about people like President Trump having to obey the law, and that he's not above the law, and that even kings aren't above the law, and that the law is for everybody, not just for little people, and we all have to follow it, and so on. And that certainly is one aspect or meaning of the term rule of law, but it's not the only one. There's another one that is equally or more important to me, and I think that it's lost on the vast majority of the American people and even on members of Congress. So I will explain briefly what that is and why it's so important to me. When the framers created our Constitution as the supreme law of the land, it was with the idea that we would follow the process. We would stick to the things that are in the Constitution, and that we would follow the process for getting that Constitution changed if we ever saw the need to change it. They purposefully made that process to change it a very difficult one. It's not an easy one. It takes 3/4 of the state legislatures to vote to amend the Constitution, and then it takes 2/3 of the House and 2/3 of the Senate to vote for that as well. In other words, a very large percentage of the American people have to be in favor of this change in order for it to happen. It can't just be a simple majority. It's a very high threshold, and that's intentional. That's on purpose. That is so that we don't just whimsically change this document all the time and make things that, maybe favor 51% and hurt 49% of the population. We don't want that kind of oppressive ability to amend the Constitution. So it's only been amended 27 times, and one of those was repealed. And it's typically not something that politicians try to do. They try to find ways to do an end run around that process because it's so hard, and they want the quick and easy fix instead of having to actually amend the Constitution. So a great case in point is Roe versus Wade, this decision from the Supreme Court. 7 of 9 justices voted in favor of it in 1973, and it became the law of the land for almost 50 years. Simply because 7 people said, thus it should be. America has always been deeply, deeply divided on the issue of abortion. Roe versus Wade was, lionized by those who loved it and demonized by those who hated it. And it was finally shot down in 2022, I think, which was a very good thing because the Roe versus Wade decision had nothing to do with the Constitution. Even the justices that wrote that decision admitted that it was a penumbra or an implied right that's not specifically guaranteed in the Constitution. The right to privacy, and that in turn implied the right of a woman to have an abortion, at least in the first trimester or the second trimester, as that decision has been interpreted through the years. But it was some justices on their own legislating, making law, imposing it on the entire country, even though half of the country was strongly opposed to it, in a kind of random and arbitrary way that was not based in anything in the Constitution. This is from people who believe the Constitution should be a living, breathing document and should reflect whatever the social mores of the time are. I think the Constitution should be interpreted the way that it is written, based on the original intent of the people who wrote it, and that the job of the Supreme Court is to interpret whether any law that Congress passes does or does not fit into that Constitution the way that it was written and the intent of those who framed it. There are several clauses in the Constitution that are problematic. They've been interpreted so broadly as to give Congress almost unlimited power to do whatever they see fit. One of these is the so-called General Welfare Clause, and that is a clause that says that Congress shall enact whatever laws they deem necessary to provide for the general welfare of the country. If we interpret that as broadly as it has been interpreted, then in some respects, we might as well take the Constitution and crumple it up and toss it into the wastebasket, because that, in essence, removes any checks and balances on Congress's power or ability to do whatever they think is right. They can, regulate whatever thing they want to. The Constitution very clearly delineates or enumerates their powers. They're called the enumerated powers. It specifically has sentences and clauses and phrases that say Congress shall do this, this, and this, and this, and this. And then it says anything that's not named in these specific enumerated powers is reserved for the states, not for Congress. Nevertheless, because of this general welfare clause, the courts have interpreted Congress as having a bunch of implied powers, and that is reinforced by another problematic clause called the necessary and proper clause, which says implied powers mean that Congress can do anything that it deems necessary and proper to achieve those implied powers. This is not good. This is why we have so many federal agencies that far exceed the scope of the original intent of the framers of the Constitution. They had no idea there was going to be a Department of Energy or Education or Commerce or Agriculture or FAA or TSA or Drug Enforcement Agency and all kinds of other departments and agencies of the government, health and welfare, that exist outside of the enumerated powers simply because of these two clauses. So I would very much support an amendment to the Constitution which would clearly and carefully define in a very narrow way what the general welfare clause and the necessary and proper clause do and do not mean in terms of the powers they give to Congress.